We're live.
Great. Welcome back to Senate Economic Development, Housing and General Affairs. And we have a couple issues that we are still addressing. Charlie or Katrina, who would like to take?
Start and Charlie will go.
Okay.
Can we both sit up?
Yes, absolutely. Absolutely. Charlie knows this. Welcome. We don't, as you know, have possession of the landlord-tenant bill yet. We are hoping it will be streamlined. The hope is that it will, be a little more specific and a little more streamlined than it is at the moment. They're working on it in Senate Judiciary, and we're hoping to have it at some point next week. So, share with us, you have a landlord-tenant issue, and introduce yourselves and share with us what your concern is and what you would like to add.
Good morning. I'm Charlie Gluckerman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I'm happy to answer any questions, and I'm also going to screen share so y'all can walk through our language as covering in class.
Just so you know, we have it, and everybody has this, right?
Yeah, it should be posted online.
Okay.
I do have extra copies
Right.
if people.
Let me just.
No, we have it.
Posted.
I believe.
For us to be.
Do you want?
We love it. This is the Senate Economic Development Committee. We love paper because what is it? It's a Vermont product.
Oh, amazing.
Okay.
Perfect. Well, I think we're covered then. You're making my job very easy.
Great. So, welcome. Introduce yourselves and take it.
And I'm Katarina Losias, the advocacy and organizing manager at the Vermont Network. So the Vermont Network is the leading statewide voice on issues of domestic and sexual violence. We're a coalition of 14 independent nonprofit member organizations serving every town in the state. In 2025, our member organization supported over 1,000 survivors accessing emergency housing, just to give a teeny tiny level set of why we're here today. And then, as you just mentioned, the bill is in Senate Judiciary, and we have worked with that committee on existing language in H772 to clarify that landlords can evict a person who causes violence without evicting a survivor of violence who resides in the same unit. And we have no further recommendations on that language. For your committee's consideration, what we present is to ensure tenants are aware of their existing rights under law by having landlords provide standardized notification of tenant rights, including at the time of an eviction notice. These updates incorporate stakeholder feedback and align with existing standards established under the Federal Violence Against Women Act, VAWA, which many housing providers in Vermont already abide by. This language would standardize the practice across the state. So by standardizing the delivery of occupancy rights, it is essential to ensuring survivors of domestic violence, sexual assault, and stalking can effectively access the protections afforded by both federal and Vermont law. Survivors frequently face housing instability as a direct consequence of the violence and may be unaware of the legal remedies available to them. A written notice ensures that all tenants receive consistent, accurate information at critical junctures, thereby reducing confusion and empowering survivors to make informed decisions during their crises. It makes real rental process more transparent, predictable, and fair. Tenants and landlords have a clearer, common understanding to the rules and protections built into their housing relationship. And now I'm happy to talk through the proposed amendment.
Right.
Okay. So we have multiple parts. I'll talk through them. I'll explain them as I go through. So we do suggest that this language.
I just see this bit at the end of your first page.
Yep, that's it.
Great.
That is it. The rest we did give you information about existing federal and state laws to protect survivor tenants. I won't go through that today. But we do suggest that this language is in the subchapter 2, the residential rental agreements. And we'd want it to be a notification of occupancy rights. So it states that the Housing Division of the Agency of Commerce and Community Development shall develop a notice of occupancy rights under Vermont and federal law. including information related to the confidentiality pursuant to 9 VSA 4474. So this information would be in order for tenants to be aware of various protections. We believe it's important that there be notice at key points in the process. So the next portion of the language we're suggesting is that the notice shall comply with the Office of Racial Equity's most recent language access report. We included this language because the notice should be accessible to all renters, and the language should not be a limitation. The language accessibility text as proposed is used in other areas of Vermont law.
Can you just expand on that a little bit? I don't know what the language access report says. Can you just like paragraphs, 10,000 big?
Yeah, so and the last report came out in 2023. It does talk through the various languages that many people speak in Vermont and is a way to have an accessible resource.
So it's a multi-language, or the notification needs to be in multi.
Yes, that's what we're saying. If you want to say that in a different way, that's fine. We just are proposing something that's already existing.
With the notification.
Thank you for asking.
So the language access, there is available for landlords, this booklet or a guide for different languages, for language access is this made available through the Landlords Association?
No, this is created by the Office of Racial Equity.
Right, but how do landlords get it?
They,
So ACCD would develop
Yes.
the notice. So you're trying to say going forward,
Oh, so this
the
is
best
proactive.
practice would be that state government issues forms or guidance, and then
In many languages,
does it.
which is a great
building.
idea. And I
thank you for.
encourage you to obviously connect with Angela Zakowski at the Landlords Association to figure out how best to do that.
Of course, well, the ACCD is tasked with doing it.
Yeah.
Is this something that is like a 2-paragraph thing, or is it a page and a half, or is it a booklet? What is it?
So, the notice that we're proposing could be as short or long as ACCD expect, but it could be a link to the state statutes. It could be a uniform PDF that every landlord has that they could include with their lease agreement. But it's just a way to understand that there are housing protections specific for survivors.
Yeah.
And then this
it-
would be an effective notice that would advise the reader that this is where you can get information in your language.
Correct. Yep.
So I just say,
Okay, sure.
this is probably a best practice anyway, right? Like we should move
Yeah.
toward state government following its own guidance. I worked on language access plans for cities and states for decades. The thing I'd love to have you react to is what I think is going to happen with H772. This is just my take on what's going to happen. I understand judiciary is narrowing it to a no trespass order.
It's actually, you missed the initial thing this morning, which is we're hoping to narrow it to 3 things. To improve, to an expedited process for a tenant that is threatening it in major ways and affecting tenants and landlords. No trespass is the second piece. And the third is creating a housing court, a study to look at how we might move forward with a housing court. Those are the 3 pieces that we're hoping to narrow this bill.
Perfect.
So, and I just, did the chair of judiciary come in and say that, or
It's what we've been working on with.
Okay. only because I don't know, I think.
I'm pretty up to speed on this, and this is what we're hoping and what we've been working on.
I think if we care about this, we might want to put it in 775, the housing bill. So that's kind of what I wanted to get your reaction to is, would this help all victims of violence or harassment, regardless of whether or not that bill
Yes.
moves forward? And should we look at other ways to advance people having an understanding of their tenancy rights and housing rights?
I think that is absolutely something you can consider. In 2019, this body worked on protections for survivors, including changing of locks, the ability to leave a lease without penalties, for their safety, as well as other protections. So there are existing protections. We have worked on some of that language in 772 that would add those protections. I think it's important for anyone to know that those exist.
Mhm.
And some of the existing language that we've been working on with Senate Judiciary around survivor protections from eviction. If a perpetrator of violence is being evicted in an expedited process, I would just urge the committee to maintain that language if any eviction related to acts of violence language is moving along, so that any unintended consequences for survivors are protected against within that language.
You may also be in a position, I mean, I used to do the relief from abuse order docket in Tunin County. I'll probably go back to volunteering to do that. It is the only court process we have where, because of the threat of violence, someone can petition without police intervention for, relief from a violent situation, and get conditions like no contact, being 500 feet or more away from the residence of the person, having guns removed, etc. What I wanted to talk to Judge Zone about, or others, is that's already a very limited process if you can't prove that you have an intimate partner relationship or a household relationship with that person. Ostensibly, if you are the landlord or somebody who is afraid that when you eject someone or no trespass them, they will cause harm or do violence, a 3-day process doesn't help us. Immediate temporary relief helps us. Hence, those judges and police officers are available 24 hours a day to say you need temporary relief. It's just a piece of paper, but it says this is too dangerous to wait 3 days or until they move out. The landlord tenant court piece is important because eventually that's what you need to be looking for, I think, is relief from a dangerous person. I mean, we have had incidents of people killed as housing providers. So I don't know, I know the relief from abuse and relief from exploitation process pretty intimately, and it works when it's written to accommodate all kinds of violent situations. Do you have any thoughts?
I think that Judge Zone could also speak to that, but one thing that I just encountered through my work is that the stalking protection order process is often used in household and like unit, housing provider, neighbor.
Yeah,
seeking.
I wrote about it.
I thank you for doing that, because it is one way to access protection when you don't fall under that family and household member definition. But I'm more than happy to chat with you offline, or I'm sure Joe Zone gets that as well.
Yeah, that's a good point. I don't know if the relief from stalking right now has a temporary injunction, like temporary relief. But we could strengthen it so that that is included in what gets you temporary relief by a judge in the middle of the night saying, yeah, you're in danger.
Yeah, and sadly, as we all know, that's only as good as it's enforced. And so that's a piece of our challenge all over. It's fine for more urban areas, but much harder to protect women who are in rural situations. Yeah, David.
If I can, I'm still trying to understand, going back to the proposed amendment.
Yeah.
Are there, do these, notifications or rights exist in a website format anywhere that's currently accessible? So what you're asking is to provide, the landlord to provide a paper copy, 3 different instances of these, of the rights, of the tenant's rights. Is that?
Yes, that's right.
accurate summary?
And I think that they're in various places online, and it's not always clear to a tenant where to look for those. So this would be a streamlined, standardized way that they would have the information about what their rights are.
Okay. But they currently exist on state sites.
Yes.
ACCD has some fair housing resources currently on their website.
In multiple languages.
In some, yes.
Are there any other required hand deliveries between the landlord and the tenant in the process,
Yeah,
such as?
there's, most of them are hand delivery certified mail, like security deposit notices. Notice that you're coming to work on the apartment, you have to give people, 48-hour notice, I think, usually hand.
But not rights related, or
There,
just trying to get.
Yeah, no,
Understand the background.
good to understand.
So federal housing authorities and people who receive federal housing subsidies already follow this rule.
So
under
the Vermont State Housing Authority already follows this. All of our state housing partners follow this.
If you're receiving Section 8 in a unit that's not
Any Section 8 housing.
already are doing this, so this would just be a uniform process for every landlord to share these rights with tenants.
And it would it be, in your perspective, from your perspective, would it be sufficient for the landlord to provide the QR code or something? This is your, the web, this is your access, this is the site, as opposed to them trying to maintain the most current format or language of occupancy rates.
Oh, it's like, I mean, that's also a good question in that there are a lot of requirements in law for landlords about what needs to be communicated at the time of signing a lease or what needs to be posted in the common area or the dwelling unit. So the only thing we require be posted at all times in a rental unit is lead related information if there is the presence of lead in the building or if it was built before a certain year. There are definitely requirements for what you have to communicate to somebody or addend to your lease or whatever.
I'm just, I'm not using the perspective of the industrial houser. I'm using the perspective of a mom and pop, who've got one or two units and how they. So that's why I'm trying to ask some background questions, because I'll get asked out in the field by small landlords.
Great.
Thank you.
No, thank you.
I think that would be appropriate to have a link that
Yeah.
they share with
That's
their.
great. And the QR code could also take you to whichever language you need it. So there are many.
That's probably the least easy thing. I can't read them.
The point is,
Yeah.
the landlord's not gonna follow
Right.
landlord tenant law like we do. They're gonna keep turning over their place. It
Mhm.
might be a couple of years. So they're not gonna maintain, but having the one
Mhm.
site, that's the site.
Yes.
That's all.
And they talk about here, the notices that need to be provided.
Yep.
Mentions things like language access, so on and so forth, most recent ones, language access. But you go and you look for that online and it takes you to a 96-page document, which wonder if that's what's intended.
That is what we intended in this language, that it complies with that report. So that report does, I don't know the frequency in which it comes out, but rather saying it needs to be in these 6 languages and we passed this in 2026. In 20 years, if those 6 languages are redundant, we want it to be associated with a current report. That's the intention.
One of the things that the committee ought to do is when we look at what has to be distributed in accordance with the law, to actually look at it.
Yep.
That will give us a real indication of what
Absolutely.
people are presenting. But
I think it's a nice suggestion. Of course, this is something I support deeply, but I have to agree with Senator Brock that what we need is government operations to require some kind of adoption of language access best practices identified in this report for all of state government.
Exactly, for everything. I mean, we need, and you need to be able to link it to that. Yeah. So next session.
Yeah. So I mean, like, I would understand the discomfort with starting to cite a report here without GovOps saying this should underscore everything that's done in state government. And if people are not aware, most language access guidance will say start with life-saving, then do, rights and safe shelter and safety, and then do like parks and nice to have things. And so often in government, if you don't do it in that order, you end up with a patchwork of things in different languages and you don't have the money for the life saving and then the civil rights
There you wind up in the book of requirements that nobody reads.
that nobody reads and forms that nobody distributes.
And this language around notice shall comply with the Office of Racial Equity's most recent language access report is already used in different parts in state law. For example, it's referenced in the CCFAP application statute. So that is kind of where this language came from.
We should get GovOps to standardize that before it shows up in more places without
Yeah, no, I don't disagree.
held by the office.
That will be up to you next year.
Yeah.
So take that, I think.
I'll tell our chief.
Right.
Perhaps take a look at it.
Terrific. And one thing when you were mentioning this, 96-page document with all of these different translations, I just told
No,
it,
it's just the guidelines associated. That's at least the document that's referred to here
mhm.
is what it is.
One section of the language access report that I was looking at and appreciated was this recommendation that each document that is available in that language
Mhm.
have the language in that languages,
Mhm.
so that, French is not Francis, Francais. And so I imagined that like something like a link on the ACCD website would look kind of like this and have the different language translations be that way.
Right. Any other questions for Charlie and Katrina? Great, then I think, thank you very much. You have sent this to us electronically. Cameron has it. And so thank you very much. We're gonna ask Cameron to come and give us an update on where we are in judiciary and what sort of the expectations are. And of the efforts to slim down this bill at this late hour. Are procrastinating.
We're just gonna walk through their amendments or bring that up.
No, you could just describe it, because I think it's all in flux at the moment, and then I think we will adjourn.
I know you're not.
Yes, Thomas, do you have to leave early?
No, I know you're not checking your email, but I'm receiving.
I'm not, because I have to pay attention to the witnesses.
Page 512, there's another email from Susan before asking for an additional change. And so my point is that we're gonna offer that. up.
We're not,
Passing it
today
over.
we're passing it over today.
But,
And I'd love to have you join me on the amendment. We just found that there were some venues that we had failed to include, Vermont venues that we had failed to include, that we need. Matt and yes, everybody, all the advocates found venues, but I think 3 or 4.
Good morning,
Good morning again.
Cameron Wood, Office of Legislative Counsel,
Back for more.
back for more. But you dragged me away. Obviously, talking about page 772, which is currently in the Senate Judiciary, and, been in there with the committee quite a few times to discuss the bill. So happy to kind of chit chat about some of the things that they are looking at tweaking. It's been a while since we walked through the bill, but if you have any questions, I'm happy to try to deep dive and answer. Some of the changes so far have been more technical, narrowing or narrow refinement of some of the language. So they've made some changes to the provisions that allow a tenant to bifurcate a rental agreement if they are the victim of domestic abuse, sexual assault, or stalking from another tenant. So if you remember, there's some sections in there that say that a landlord can't terminate the rental agreement for an individual because the individual is the victim of domestic abuse, sexual assault, or stalking. And we've kind of cleaned up that language to say that it originally said the landlord shall bifurcate the agreement. And they've changed it to say that the landlord may bifurcate the agreement if the protected tenant has submitted the request in writing. the landlord shall bifurcate the agreement if that request in writing is submitted with the court order to, I don't know exactly what the language is, it's the landlord shall bifurcate the rental agreement in order to eject the perpetrator if the written request is included a copy of the court order that requires the perpetrator to do it. So slight change there. May request versus when it has to be done. And then the committee has also looked at some of the language around when to terminate the rental agreement based on criminal activity, acts of violence, etc. There's some tweaks to the language there. The current version is adding in a requirement that there has to be an ongoing threat. Currently, the language just says you can terminate based on criminal activity, illegal drug activity, or acts of violence, which is a threat to the health and safety of other people. Right now, the language on the amendment says it has to be an ongoing threat to the safety of other people. That's still a discussion point among the committee, so I don't want you to think that that's where they've landed, but
Right, but
that's at least a point that we've
addressing
been
the-
discussing.
The worst of the, the most
Been discussing
impact.
that. So one of the other, probably the largest change so far that they have, I think, settled on is the language as it came over from the House. You remember when we did the walkthrough? There's currently a subchapter that governs ejectment actions. Subchapter Title 12, Chapter 169, and Subchapter 3 governs Superior Court ejectment. The House version created an entirely new subchapter for just a subset of ejectments, non-payment of rent, breach of the terms of the rental agreement. They've removed that entire subchapter. They've gotten rid of the entire new subchapter, and what they've done is they've kept the expedited hearing for cases that are based on the criminal activity, the acts of violence that are ongoing threats to people. So they've kept the expedited hearing section. That expedited hearing has to be within 21 days after the ejectment case is filed. So that piece is still in there for now. Some of the things that we were discussing this morning and they've been working on is the trespass language. And so there's been a lot of discussion about that. So currently
We're talking about no trespass once evicted.
yes, ma'am. And so currently, we remember from our previous discussions, if an individual has been ejected, but they're invited back from somebody else on the property, they can come back. And the courts will not uphold a no trespass order in that scenario because the person is a guest of somebody else living there.
This was our Decker Towers challenge.
And so there's language in the bill that would allow a landlord to issue a no trespass, and the court would have to uphold it if the landlord receives the tenant's consent, the individual is violating the lease terms, or the individual is violating state or federal law on the property. On the tenant consent, they've discussed adding in some language to require that consent be done on an individualized basis, so that a landlord cannot put into a rental agreement to say that by signing a rental agreement, you provide consent to the landlord to be able to no trespass any of the guests in the future. So they're going to require it to be examined on an individual consent basis, and any type of provision that I just described would be void against public policy. We'll talk about adding that in. They've talked about adding in a 1-year requirement, a 1-year renewal requirement. So if you issue the no trespass order under
It
this
gets reviewed in a
section,
year.
has to be reissued every year. The thought there was, you get ejected from the property and, 5 years later, your
You're
life,
over, right?
right, your life has changed, and, you know somebody who moves into the property, and, they may want to invite you over. So there's a 1-year renewal that they've discussed adding in. they've discussed adding in a provision here to clarify, to make it clear in the language that if you are ejected from a dwelling unit on a premises, the landlord can issue the no trespass and you wouldn't be able to come back as a guest. Currently, the language would allow you to come back and it would require the person to violate the lease terms or violate the
Right.
law before the trespass could be ordered. So it doesn't really accomplish the goal that I think the advocates were trying to accomplish. So they talked about adding in a section that says, if you've been ejected, then you could be issued a no trespass and you wouldn't be able to come back as someone's guest. From there, they've talked about whether or not to narrow that language to say, if you've been ejected because of a termination, because of a breach of the rental agreement or the criminal activity, do you want to narrow that ejectment to just the cases where somebody's been ejected because they violated the terms? The argument was, well, what if I get ejected for no cause? And now you can issue me a no trespass order and I can't come back, but I may not have done anything wrong other than to stay and try to argue in court that I should have been able to stay. So there's some discussion around that. Let's see. There was some discussion around the security deposit. The statute says that the security deposit is limited to 2 months rent. There are some municipalities that have it at 1 month rent. And so they've discussed adding in some language to clarify that a municipality can have an ordinance that provides for less security deposit than the 2 month cap in statute. And then I think that's where we're at. There's been a few other questions.
What about the housing court, that discussion?
Oh, yes, ma'am. My apologies. That's
No, that's
the other
okay,
big
that's key.
They added in, as of right now, we have, at the end, there is a study to require the judiciary, and it's just having the judiciary issue a report back at this point. But it's January 31st, 2027. The court administrator shall submit a report on the feasibility of implementing a dedicated housing docket in Vermont to cover the terminations of the residential rental agreement and ejectment actions. And then there's some information about what they have to examine as part of that report, but that is in here as well.
Good, that includes costs and time and, yeah. Great. That is helpful to us.
So the current plan is for them to do whatever they're doing, and then is it definitely coming over here or is it okay? So, right.
No show timeline to that effort.
I think we're working as fast as we can. They have a lot of bills, just like we have a lot of bills. And they're also a warning committee, which has been given this deadline of next Friday. So we're all working against a tough deadline. I think we'll be given, if we, we'll see what happens. I think everyone's clear on what we're swimming, the current we're swimming against. So I think we're all moving as fast as we can,
And I
and
have,
we're in close communication. I think the good thing is that we're in sync. The chair of Senate Judiciary, and I are working closely together with our legislative council and advocates on both sides. So I think we are making good progress given the time frame where we are in legislative session and what we're actually capable of taking on.
I don't know if people saw the article by Cardi.
Yes, we did. Yeah, I saw it.
I would recommend it.
Well, it ends with you. It ends with a quote. So, we all should be following how the 5 of us are quoted in the paper on different issues. Anything else, Cameron, just to keep up this update?
no, those are the changes as of right now that we've looked at. I have some other, recommended changes for probably this committee if you decide to move forward with the bill, but happy to address those.
Right.
It's
Yes, and you have the one from the network, obviously. They said that we have that. You have
So
that.
I missed a little bit of the initial testimonies that came in late. I think
Charlie, Yeah, if you haven't sent it to Cameron, please send it.
You know, so I have it.
Okay.
So the Judiciary Committee has been working to address the concerns that were raised about the language on bifurcating the agreement. And that's what I was walking through, when the
Yeah.
landlord may bifurcate versus when the landlord shall bifurcate. It says that the landlord cannot, it's phrased slightly differently, but it's meant to state that a landlord cannot require that documentation be submitted if a request to bifurcate is provided by a tenant, so. And it provides the written request. The landlord can't go to the tenant and say, you need to give me some sort of court documentation before I'm gonna review this. There's a section in there that would not allow that. The Judiciary Committee is reviewing and making those changes. The Judiciary Committee felt that the notice, the information notice to be provided to tenants was a better suited for this committee, so they are not making that change.
Okay, any other questions for Cameron? And then,
He presented the notice language.
Yes, good.
yeah, they just did,
Yeah, so I'm just making sure you know Judiciary Committee is not looking at that.
we are. Great. Any other questions for Cameron? Terrific. Well, then, thank you. Everybody have a good weekend. Thank you, everybody, for all your efforts. And enjoy. Happy May Day again. I feel like, where's our makeup? Daphne, we can